Do I need to retain an attorney, and how soon should I?
That's a great question. It's my belief that an injured party by a defective product should hire an attorney or should seek the advice of an attorney as soon as possible. One, because oftentimes these companies or the insurance companies for these companies try to reach out to the injured party and quickly try to resolve those cases for pennies on the dollar. And these injured parties are often either injured in a state where they're not thinking clearly, or they don't know their rights and they don't know what they're entitled to recover for. So they're settling their cases or resolving their cases without properly knowing what their rights are. And these companies try to take advantage of that situation. So that's step one, is to get a good attorney between you and the insurance company and the defendant so that you don't give away something or give up your rights. Second, it's important to hire an attorney early or consult with an attorney early because evidence needs to be preserved. In product defect cases, the product itself and other evidence often gets thrown away or destroyed or changed or modified in some way after the accident. So it's critical for the injured party to hire an attorney or consult with an attorney so that evidence can be preserved. Because sometimes in cases that evidence is critical to the success of the case. In addition to that, the law is complex in these types of cases, and these companies hire big law firms with lots of money and lots of attorneys to litigate these cases, and I don't believe a reasonable person could adequately represent themselves without proper counsel. So it's, in my opinion, very important to have a top-notch plaintiff's law firm fighting for you in a product defect case.
And what about time limits? Do I need to sue within a certain period of time?
Right. That's another great question. So in California, an injured party or the relatives of someone that was killed by a dangerous product have 2 years from the date of the injury or the death to file a lawsuit to recover. So again, a plaintiff's attorney needs to be consulted quickly and early in that process so that the evidence can be preserved, but also so that the case can be investigated and other evidence and research can be done prior to that 2-year deadline.
And you mentioned earlier a product liability case involving an aerosol spray. Let's say the damage is cumulative. Is there a time that I need to file in this after I find out I've been injured from that?
That's correct. You have to file when you're either injured or you discover using reasonable and due diligence that a certain product caused my injury. So while you might not know for sure whether or not the product was responsible for your injury, you have a duty to go out and find the evidence, find the facts to determine whether or not that happened. So in some circumstances, a plaintiff can recover beyond or file a lawsuit for wrongful death or personal injuries based upon a dangerous product if they couldn't, using due diligence, have discovered that the product was the cause of their injury.
You mentioned also that the seller of a product, not just the manufacturer, might be liable. Does the seller have to be aware that the product is defective in order to be also responsible?
No, the seller is not. The law around product liability is a function of society, and it's a policy determination that the state of California has made, that the companies that are in the chain of custody, from the designer to the manufacturer to the distributor to the seller, are in a better position to bear the risk of those dangerous products as opposed to hanging the plaintiff that is injured out to dry. So while the seller might, in some people's mind, be innocent in this in a case, that doesn't absolve them of liability, because oftentimes these sellers buy products from overseas manufacturers and companies where U.S. law cannot reach. And in that case, if the seller wasn't responsible, then the only viable other party would be the manufacturer in a country like China. The plaintiff would not be able to recover a dime. So as a society and as a state, we have made the public policy determination that we would rather the seller bear the responsibility for that dangerous product as opposed to the plaintiff being unable to recover at all.